much, Heike, for this really generous introduction. It is really a pleasure to be here in Mannheim, I think for the second time, and to be sharing a few thoughts on the question of remedies, right? So I have to start by saying that my immediate impulse whenever regulation or the reform of Regulation 1/2003 comes to the picture is to immediately talk about remedies. So you can imagine how happy I was to jump on this opportunity to indulge a bit on this hobby horse of mine that has kept me busy thinking for the past few months, right? So then the plan that I have for the coming minutes is to give you a picture as to why I've become convinced that this is an area that deserves close scrutiny, that deserves dialogue between academics, regulators, and lawyers. And then I will try to sketch a few ideas into the direction or the sort of issues that might deserve a closer look into that, right? So then before I move on and before I forget, I have to acknowledge from the outset the great help that an illuminating conversation with Thomas Cramler from the European Commission, because, well, you will discover quite quickly as I go on into the presentation that for an academic, it's quite difficult to get a sense of certain things without having a chat with someone who has been close to the action. So here comes the acknowledgement to what Thomas had helpfully explained a few weeks ago. Right? So then, having said that, I would like to start Never mind. Here we are. Thank you. But about a few words, as I was saying, as to why I think it is worth having a conversation about remedies. I think why this setting is particularly apt for this sort of conversation, right? And in this regard, I think the first point I would emphasize, and I think the one that deserves close attention, and I think this has become already apparent throughout today's conference, is that the center of gravity of competition law is changing. Thank you. The center of gravity is changing in the direction of remedies. And this is so for a number of reasons from what I've seen. I think one reason was very much present in the last panel is that remedies are becoming increasingly complex and remedies are becoming much more far-reaching than we used to be. I think I have to look no further than the reference that has been made to Google Shopping, I believe, to illustrate that particular idea. I don't think it was market engineering, but what is clear, and I think what has been clear from the discussion, is that it involves some sort of product design. So then there was a remedy that sought to redesign the way a search engine worked, and that rearranged the relationship between the search engine and its competitors and creating a system of auction that didn't exist before. Right? So then this means that the days of the negative obligation that would be administered on a one-off basis is not something that is comparable to the sort of remedies that we see today. Right? Then I can give other examples, but I think what's been clear from those examples already is that these new remedies are more ambitious in the sense that they lead to the imposition of positive obligations, an obligation to do something to proceed in a certain way, and they also come with monitoring obligations. So these are remedies that will not be administered on a one-off basis, that will typically demand some sort of follow-up over time and might demand from the authority also key choices in terms of the design of the remedy. Right? So then this is intervention that is more commonly associated with formal regulatory regimes. And I guess the key point from my perspective is that they come with challenges that are not present or that were not present in the remedies of the old days, right? So this is one reason why I think the center of gravity is shifting. Another reason along the same lines is the fact, and I think was immediately apparent in the context of conversation between Heike and Mike at the very beginning, is that the effects analysis, or looking on a case-by-case basis into the effects of a practice, is something that is progressively falling out of favor. I think Mike has been quite explicit about the fact that looking on a case-by-case basis into the impact of a practice does not necessarily strike the right balance when it comes to intervening, right? So then once the bio-object approach is sort of gaining favor again, once the pendulum is swinging again towards a bio-object intervention, well, inevitably remedies will come to the fore and the attention will come to the remedies. And if you combine the two factors that have already been mentioning so far, so then remedies becoming more complex and far-reaching, and the effects analysis falling out of favor, where inevitably the spotlight will be placed on remedies. And this is relevant for, I would say, a fundamental reason. And this is the third one that you see on the slide. And this has to do with the fact that Regulation 1/2003 was only partially prepared for these sort of far-reaching and complex remedies, right? And I don't say this as a criticism in any way. I think some of the sessions we've had so far, I think were quite helpful in illustrating how far we've come from that. I think because I'm an academic, I can do this sort of legal archaeology. I can look into how things were in the days of Regulation 17, and it's a completely different universe. So I think it's absolutely reasonable that the challenges that come with what I've sometimes called proactive remedies were not present in Regulation 1/2003. I'd like to cite myself, I mean, going back to Martin's practices, this is joint work with Andriani Kalindiri, and I think the key takeaway from this slide is simply that the sort of far-reaching complex remedies I was describing before, changing the design of a product, imposing a duty to deal, perhaps altering a business model or banning altogether a business model and therefore requiring a company to adopt a new business model, this is something that was almost completely absent from the days preceding Regulation 1/2003. So this is a wholly new animal. So it's only natural that because of that, Regulation 1/2003 was only partially prepared. And this is something that is clear when reading the regulation itself, the implementing regulation that Max has been describing before, or even the manual of procedure. Right? So the manual of procedure, you go, it's almost 300 pages. You will have almost 2 pages dealing with remedies. And that means that to some extent, and because of the novelty of the issue, there's a slight mismatch between, I would say, the reality of enforcement and Regulation 1/2003. There is to some extent a gap between the two, and a gap that has emerged over time. And that was one of the primary motivations why I reached out to Thomas, just to get a sense of certain things, right? So then going back to an example that has already been discussed, Google Shopping, I think it's particularly helpful in illustrating this mismatch, right? So then Google Shopping, as I was saying, led to the redesign of a product. So we moved from this, which is taken from the original slide, from a commission presentation, then the product was redesigned to look along the lines of something like this. This is something that I prepared for another conference in Brussels, and over time it evolved into something like this, right? So then consequential changes to the design of a product, and consequential changes, and this is the crucial point here, that took place without any sort of legal framework, right? Then as an outsider, what I found interesting is that all of this negotiation, all the back and forth between the European Commission and Google took place in the absence of any sort of procedural or sort of institutional mechanism enshrining the context and the situation in which the dialogue takes place. Right? So all of this took place in an informal way. Why? Well, because in the original word of Regulation 1/2003, this would not have happened. Right? I think if one goes back to the days before Regulation 1/2003, this is simply something that would not have been imaginable. Right? So then in a way, there was the assumption that the remedy would be a one-off, and that with the decision establishing the infringement, the issue will be over. But what we realize now is we have remedies that might require monitoring, or the remedies that require implementation over time. And the reality of the law, at least as I say it, is that, well, there's no real framework for or to acknowledge this reality, which is, I would say, an inevitability of enforcement, at least in some markets, right? And this mismatch between, I would say, the reality of enforcement and Regulation 1/2003 is not without consequences in practice. And this is what I would like to insist upon. I mean, at least looking at it from the outside, I get the impression that the situation is suboptimal, at least for all parties involved, right? So then if we are from the perspective of complainants, well, complainants from what I see are quite noisy. So then complainants have been insisting about the fact that the remedy still 5 years after is not really addressing the problem. And there's no procedural mechanism for this to be incorporated. I would imagine that from the perspective of a company subject to a decision, there is this Damocles sword that is hanging over because there's no real decision stating, well, the remedy is as implemented by the company, putting the or bringing the infringement to an end. So this is something that is not made explicit. And I would imagine, but I'm happy to be corrected, that from the perspective even of the authority, this may also be suboptimal, in the sense that 5 years after, we're still talking about the decision, and 5 years after, some might say, well, the issue has not been addressed, right? So this is where I'm coming from. And this is the sense I get, that perhaps some thinking about ways forward and some thinking about, well, how to address the emerging reality, which I will insist once more, is inevitable if we want to have effective competition. Well, well, how do we deal with this, and what are the sort of ways forward we can take in that regard? And this takes me to the second part of this speech. Okay, well, what are the issues, or what are the legal matters that might justify some sort of discussion? I think there are matters that have already been touched upon, at least to some extent, and which are of a substantive and an institutional nature, right? So then from the substantive side of things, this takes me back to some of the frequent comments that are being made in relation to enforcement recently. So some people might say, well, remedies are not proving to be effective. Remedies are not addressing the issues, and we need more effective remedies, right? Then this comment, at least to some extent, depends very much on what we mean by an effective remedy. And I think this is a discussion we need to have, if only because it is not entirely clear that we're all on the same page when it comes to a discussion about what an effective remedy is in competition law. When one reads between the lines about these complaints, what some people say when they claim that a remedy is not being effective or has not been effective, what they effectively say is that competition has not flourished again. So then after the practice and once intervention has taken place, no new competitors have emerged on the market. All the small competitors have not thrived following intervention, right? So then the complaint here appears to be that the remedy has not restored competition or has not led to outcomes in which we see players thriving again or more than they used to thrive prior to intervention. Of course, the key assumption underpinning this understanding of effectiveness is that the role of remedial action in competition law is to restore competition, right? So then this is a view that is reasonable, but for the purposes of my presentation, the only point I will make is that this is not the only view, and this is not necessarily the mainstream view about what the role of remedies is in competition law. So let me mention simply an example as to why one might say an effective remedy is compatible with a situation in which we don't see competition re-emerging or competition flourishing. Take the example of a refusal to deal, right? So then the remedy in a refusal to deal case is, as we all know, a duty to supply. And one could reasonably take the view that a duty to supply does not mean, or is not a promise, that the would-be licensees or the recipients of access will be able to flourish in the market. One could reasonably argue that the remedy is effective insofar as it gives effective access to the input or infrastructure that is being requested. But one could say nowhere was there in competition law a promise that following access to the input or infrastructure, actually the new licensee or the company gaining access to that input infrastructure would be able to thrive. That's a separate question. but there was no promise whatsoever that this is what would happen, right? So then I'm not interested in taking views in this regard. So this is not the point of my claim. It is rather that in the context of this forum or similar ones, we need to have a serious conversation about what the role of remedies is or should be in competition law. And I think from that perspective, there's a couple of discussions to be had. I think there's a matter of positive law. I think this is a question that emerges, and I would say might emerge in the near future, about whether, as a matter of EU law, an authority might be entitled to impose restorative remedies, remedies that seek not only to bring the infringement to an end, that is to say that impose a duty to access, but actually enable competition to re-emerge and allow for the rivals to flourish once more following the implementation of the practice. And in that regard, there's some discussion on that. As much as I am tempted to, I will not get into the details of that, but I will only mention that the case law on whether there is scope for restorative remedies for more ambitious intervention that has already been mentioned before is controversial. So it's an interesting discussion to be had as a matter of positive law. But I think the fact that we might have a discussion as a matter of positive law doesn't say anything about the possibility of having a normative discussion of saying, well, should we not, irrespective of whether law as it exists now allows for the restorative remedies, why not having a discussion about whether it should be, we should go in that direction and whether we should move towards restorative remedies. And I think that's a really interesting discussion. I have a few points in the interest of time. I will not mention all of them, but I think if we're going to have a discussion about the desirability of restorative remedies, a number of questions that I ask myself, and I would really be delighted to hear your views on that, whether now or during the dinner, is first of all, well, if we go in the direction of restorative remedies, is this something that is going to be applied across the board? Or are we only going to select certain situations when restorative remedies are going to be imposed? So there's a question that at least I find interesting. And then if we're going to impose restorative remedies only in certain circumstances, then how are we going to identify those circumstances? Is this something that is going to be left to the discretion of the authority? Or is there going to be some sort of procedural framework that through which we are going to identify when restorative remedies might be justified, right? So then that's a couple of questions that I ask myself. Another interesting question from my perspective, well, what are the consequences in terms of resources? So then the experience of the past, say, 5 to 10 years shows that the sort of proactive remedies I was describing before are demanding in terms of resources. They require monitoring, etc. As Mike was highlighting previously, well, what are the consequences of going down the road of restorative remedies? To the extent that the ambition would be to restore the competition that existed prior to the extent that the aim is to kickstart competition and not simply stop the practice, well, the implications in terms of resources are quite interesting. And along the same lines, a final question, well, how are we going to figure out, how are we going to design a set of benchmarks when going down the road of restorative remedies? So when it comes to substance, those are the questions that I ask myself. When it comes to the institutions, well, I would make a few points. I will not develop these points at length, if only because dinner is awaiting. But these are some thoughts that I have when pondering about the desirability of changing, at least to some extent, the institutional setup that we have through Regulation 1/2003, right? And the first point I would like to make when it comes to remedies, and in particular the complex remedies, is that the set complexity cannot be wished away. And this is something that, at least from the perspective of an academic, is important to emphasize. If we go back to the example that I gave previously about the refusal to supply, even if we accept that it is justified in a case to impose a duty to supply, even if there's no question about the substance of the case, it is clear that it will come with a number of challenges along the lines of the design, the implementation, and of course, the monitoring, right? So then those challenges cannot be eliminated simply by going down the road of the principles-based approach to the remedy, right? So then if an authority, instead of formally imposing a duty to supply, instead of formally detailing the conditions under which the input is to be supplied, simply said, well, bring the remedy to an end and then figure out the way in which you want to do that, well, the problems will not disappear. If anything, this principles-based approach to the remedy might make some of the problems more difficult to address and even more daunting down the line, if only because of the legal uncertainty it creates and because of the consequences from the perspective of other stakeholders that might create. So this is one of the problems that I would emphasize. The second problem, I think, is quite central, and I think it's to some extent a consequence of the case law and relates to the choice of the remedy. I think this is something that I've seen repeated very often, and I think it's a case law that is eminently sensible. I think the court has ruled that the commission cannot impose a particular remedy if there is a less restrictive alternative. And as I say, this point is unquestionable as such. The impression I get, and I would like to get feedback on that, is that this sometimes means that it has, so to speak, a paralyzing effect on the authority, right? Because there might be less restrictive alternative, then the authority might be less prescriptive than it would otherwise have been. And to the extent that it has this paralyzing effect, to the extent that it prevents the authority from being bold and going down the road of the remedy that would effectively address the problem, this is something that needs at least discussing, right? So then anything that might prevent the sort of bold, decisive action that a case might justify, I think needs at least revising. So this is an important point to bear in mind. And I think when looking back at the old cases, the impression I get from the likes of AXO or even Continental Can is that in the past, the Commission has been bold. In the past, the Commission has been prescriptive as to the nature of the remedy. And this bold action has succeeded before the court, right? So then this is an important point, in particular, given the nature of intervention that digital markets, among others, demand, right? So then that's the second point. Then the third point is a hobby horse on mine, but I will exercise a great deal of self-restraint. Those who have read me know that I've very much insisted in passing the view that the remedy and the substantive assessment in a case are two sides of the same coin. So then in a way, I see an element of artificiality when some distinguish between the substantive assessment and the remedy itself. I see the two as being one and the same, right? There's a host of reasons why, but I will not insist on them. The only point I will make here, and what matters from my perspective, is that to the extent that substance and remedies are inextricably linked, I think the thinking about remedies should come very early on in the context of a case, right? So then the end game of intervention in a competition law case is to rectify behavior, right? So we establish an infringement, or we seek to establish an infringement because the end game is to rectify behavior. Well, if that's the case, then the impression I get is that the remedy or discussions about the remedy should come earlier and front and center, say, from the stage of the statement of objections, right? So then those are the points. And then when it comes to the last point towards a legal framework, that sounds daunting, in particular at 7 p.m., but I will leave it in the form of a few points that I would say are important if we are going to think about these matters in a systematic way, right? So then along the lines of what I was saying, one key lesson I would say one would draw from the past few minutes is that the reality of remedies has to be acknowledged. So there's to say the law should reflect the reality of the complex remedies. So then a fiction, I think, helps no one in that regard. And that goes as well when it comes to some aspects or some dimensions of the administration of those complex remedies. Another aspect that I think is quite prominent involving third parties. And in that regard, I think there is a thing to be had about expanding the scope of market testing and say, well, if we do have market tests of remedies in the context of merger control, if we do have those in the context of Article 9 decisions, well, would it not make sense to expand the scope of market testing towards Article 7 formal infringement decisions? And then the last one, provide legal certainty, right? So then I've mentioned the word limbo a number of times, and the fact that cases like Google Shopping show how the issue of the remedy can linger many years after the decision is adopted. I said also that this seemingly benefits no one, right? So then if some tweaks can be introduced to enhance legal certainty from that perspective, I would say that this would be a gain for the EU competition law system as a whole. Well, that's me. Thank you very much again, Heike and Uwe, for the invitation.
Yeah, we have some time for questions, not too much, but some time. Max.
Thanks a lot. I'll try to be very brief because I'm aware of the timing and the dinner incoming. First of all, thanks a lot, Pablo, because it was very interesting. There was a lot of food for thought and a lot of stimulating comments. I have two quick comments and two questions. The first comment is about what you, not only the shopping story, but in general, our remedies policy. I think, generally speaking, we have to be aware of the fact that there is a tension between two different approaches, two extremes. The one extreme is just to write a cease and desist in a decision. And let's not forget that this is what happened in shopping. There was a cease and desist. And then it will be somewhat unavoidable to have a series of discussion with the subject of the investigation of what the cease and desist means and how to interpret it. I think it's natural. Perhaps in Google Shopping, it has been a particularly evident examples with a lot of public resonance, but I think it's somehow unavoidable. The other extreme is to have extremely prescriptive decisions. In that case, there's going to be less scope for discretion, but of course, there is more perhaps margin for error. So I don't think necessarily that we can say that one approach or the other is better. And I think that in some cases, unavoidably, it's going to be a little bit of gray territory. And also unavoidably, so it's for the Commission to try and test in which case which approach works better. But again, it's just a general comment to emphasize that there is no one size fits all when it comes to remedies. Second point on restorative remedies, I welcome very much your invitation to start a debate on that because I think it's important. I do see the challenges that you're mentioning from my personal point of view. At the same time, I see the merit in some cases, at least, to have perhaps a more interventionist approach. But in general, I think it's a topic that is worth having a discussion on. Now, the two questions. In the first slide, you mentioned the decline of effects analysis. I don't know if it was a provocation or anything, but I'm not sure I understand what you're talking about, because frankly, I do not see a decline in the effect analysis in our decisions, and I do not see it in the court's case law. Perhaps we've been looking at different decisions and different judgments, but it would be helpful to have a clarification on this. And second, the stats, I think in the next slide, I see that they stop at 2004. I was just wondering if you had done the analysis also for the following period, and what is the result of the analysis? Thanks a lot.
Thank you for the great questions. Perhaps I start with that, yeah. So then there is that, I think, and I will promote yet another paper of mine. So then, and I have another bar, it stops at 2017, and what we see is an explosion, actually, of these sort of proactive remedies cases. I think what we see in terms of post-regulation 1/2003 is an interesting phenomenon. So then enforcement, our figures told us, have moved to the two extremes, right? So the sort of Google Shopping-like cases, if you like, and you have many in the energy sector, in telecoms, etc., where you impose these sort of proactive remedies that are far-reaching, and then you see the sort of basic competition law stuff like cartels, right? So then this is where enforcement has moved, right? So then I'm happy to provide the figures until 2017, but you will see a substantial increase of this sort of proactive, complex, far-reaching intervention of that nature. So then that's a good point. On the second point, no, I think it's a good point, but it was not about the decisions of the European Commission. I think this paper actually looks into the number of paragraphs and how the number of paragraphs has gone up. So I think so your example of McGill is one that we used actually. So then if we look at the number of decisions adopted by the European Commission, you see the output, as Heike was saying, has remained fairly stable. But if you look at the number of paragraphs, you guys have exploded in terms of productivity. So that's actually very, very clear. So I don't see that. But what this conference tells us is that the pendulum is swinging, right? I think, and the path of the law is low. And then, for instance, we've seen that the case, the Court of Justice has incorporated the case law effects with some lag, etc., has embraced that. And I'm not saying, I was not implying in any way that you were not doing that. What I was simply noting is what was said. I mean, the way this conference has started from the outset said, well, we've gone too far in the direction of effects analysis. And I was simply echoing that sort of comment. And the impression I have, I mean, going back without being an expert of German competition law, Section 19A in a way is an expression of that as well. So then it might take a while, but I think the mere fact that we're having or we're rethinking those aspects, I think is already telling, but it was not in any way a comment on specific cases taken by the Commission or indeed the case where we fully agree.
No, thanks a lot. Also from me for the very thought-provoking speech. And my reaction is more comment than a question, but I'd obviously be interested in your views. What I find difficult to come to terms with in the context of unilateral conduct is that notion of one-off and maybe what you term here as reactive, or the notion of a remedy that simply tells the company to cease and desist, and that would then be the end of the story. Because I think in almost all unilateral conduct cases, no matter what the authority says, there is a need for the company to actually actively do something. A cartel, you can stop meeting your colleagues at the airport hotel. That's easy. But even if you have an abusive rebate, you have exclusivity conditions, you need to go back home as a company, you need to revise your price lists, you need to revise your contracts, and you have to constantly monitor, self-assess whether or not your new price list is compliant or not. So in that sense, I think compliance is always a continuum, and I find it difficult to identify cases that really would be one-off, and where compliance could consist of simply no longer doing something you've done in the past.
It's a great point. I think it's not something that we ignore, but I think if you think, I think you gave a couple of good examples, right? So let's take in an even, I think, more graphic example for these purposes, which is that of an exclusivity obligation. I think what you're saying about compliance, or making sure once you've been, you've received a fine, you will try to make sure that you don't infringe competition law, that you're not a Michelin who has been receiving decisions after a number of years. So that's absolutely true. But when it comes to the administration of the remedy itself, when it comes to closing the chapter from the perspective of the authority, a one-off suffices, right? It's well, this exclusivity obligation is or amounts to an abuse of a dominant position. That's the end of the story. Remove those exclusivity obligations, do not impose those. MFNs could be another good example along those lines. So then I'm not denying what you're saying, but I see a difference in terms of scale and in terms of closing the chapter of the decision itself between, say, an MFN or an exclusivity obligation on the one hand, and then redesigning a product or demanding that a business model be changed or imposing some sort of price-related obligations along those lines. So these would be issues that, when it comes to the decision itself and not with compliance with the future or with future intervention, demand some sort of continuing, right? But I take your point. I think that I don't think we disagree in any way. No, thanks so much.
So actually a bit along the lines of Wenzel, I was wondering, when I think about, so your claim at the outset, remedies have become more complex, and of course the unilateral conduct cases are the ones which one would look at. And if I try to think of very complex remedies at the EU level, of course all the Google cases come to mind, and then MasterCard maybe. But not so many more. So I'm wondering, is it really the change that you have described? Is it really something, just a challenge to adjust to the new, to the transformation of the digital sector? So which then we have maybe partly solved with the DMA, or is it something more fundamental that you would claim that cases have really, or unilateral conduct cases have across the board become more complex? And if that were so, I would wonder why. Why have cases become more complex in that regard, with regard to remedies, after the change from Regulation 17 to Regulation 1?
Okay, no, I think great point. I think if I should have started that way. I think I would say the first part of my answer is not only related to digital and this, well, I was mentioning these cases because they had been discussed, and I think others that come to mind. But when things about the phenomenal saga of cases in the energy sector, they went very far, very often. And I think they reshaped some markets in fundamental ways. But I think one example that came to mind as I was listening to you is the Swedish interconnectors case, which was fascinating in a number of ways. So then we have a company that essentially manages the transmission system in Sweden, and the way in which it managed the system resulted in the export of electricity being blocked from, or being discontinued, right? And this was considered to be a response to a problem of congestion that was not considered to be in line with Article 102 by the Commission. This was decided in an Article 9 case. And eventually, the whole market within Sweden was rearranged. And we had cases like those. I think I can think of any. I can think of the very own E.ON case, which led essentially to a structural divestiture. And those cases, I think, were, if anything, more ambitious than some of the cases we're seeing, right? So then when even through Article 9 intervention, we led to, or a company accepted to expand capacity. So these were fascinating cases. So I wouldn't say these are new cases. What we might have seen is, well, a trend that you identified is that these cases were decided through Article 9 decisions, and now these cases are being decided through Article 7 decisions. So I think this, to some extent, my perspective as an outsider is that there has been a change in policy. Or perhaps from a policy-making perspective, adopting Article 7 decisions makes sense as setting precedents, which is what Max was saying before. So that's part of the explanation. So then I guess the question I ask myself is, what do these sort of utilities cases and others have in common? Another, which is partially an Article 101 case, which is very proactive as well, is the CDS case, the credit default swaps case, which was eventually an Article 9 case, but that was quite interesting as well. And what the CDS case, what the utilities cases, what the digital cases have in common from my perspective is that you're dealing with segments of the value chain where there's little to no scope for competition. And my interpretation has always been that whenever you have a segment of the value chain, the sort of usual bread and butter one-off remedies do not work, right? So then whenever you have a bottleneck segment at some level in the value chain, you will need some sort of proactive intervention. So my explanation would be that. And the explanation why we've seen this explosion of cases after Regulation 1, well, we saw liberalization, we saw competition law accompanying the liberalization process, we saw digital, and the combination of liberalization plus the emergence of these new bottlenecks in the digital economy means that if you want to have effective competition policy, you will need this sort of proactive remedies. So that's the explanation I've always been given. But I think those, but I think.
So maybe just one brief point. When you were asking about, potential candidates for restorative remedies. So I was thinking about, for instance, if you have a 101 case where you have like collusion about a specific practice, non-pricing practice that has an exclusionary effect, foreclosing effect. So strictly spoken, a cease and desist order simply would mean stop colluding, right? And then firms acting legally. But what if they have already implemented that measure? And until now, my thinking is it's quite unsure under 2003 if the authority could do something about it. It would make sense to me if they had the power to say, stop that practice at least for a certain period of time. Then we may see whether that within competition could sneak in again, but at least for a certain period of time, so they should have the capacity, the competence to prohibit this.
Okay, well, that's interesting. And that goes to the heart of the questions that I ask myself. Well, what is exactly the scope of restorative remedies? So then my instinct is that restorative remedies probably have no place everywhere. And you were coming pretty much from the same place I was coming from. So when I think of a cartel, could we envisage or imagine restorative remedies in the context of cartel conduct? Well, perhaps. Does it make sense? Well, that's another question to be had, right? But I have to say I have no firm answers on that. But in a way, what you're presenting is another sort of more creative approach to remedies, whereby you intervene on a temporary basis, or you say, well, let's take action in the interim along those lines. So in a way, it's even a different approach to restorative remedies. But and as I say, this is the sort of conversation I was expecting to be having. So, I mean, at the risk of disappointing you, I mean, my impression is that I would love to hear more about that, because it's not something that had come to mind. So, great point.